Everybody hates the last speaker. I'll try to be brief as much as is it possible. Maybe it's a punishment for me because in Warsaw I was the first one. So now I'm the last one. It reminds me on biblical, who was the first will be the last, and who is the last will be the first. Well, this is connected with religion, obviously. For those who know me and my work, most of my work is connected with legal theory, theory of law and state, criminal law and religion and religious legal systems. So I'll try to speak on something which is completely different, very specific aspects of privacy law which is connected to religion. So let me start. I'll read a little bit and then we'll talk, I hope, shortly. One of the most important manifestations of private law is contemporary European privacy law, and of course GDPR regulation, which was initially intended for, as I said in Warsaw, for business entities. There were intentions of the regulatory bodies of the European Union to regulate use of private data by big companies which have been expanding its networks and profits by using data which was private and sensitive. This is a very important historical aspect in the development of the material which is today considered as a major tool for halting corporate sector from penetration into the protected world of private area and family life. All this was created as a safeguard and a guarantee that private and sensitive features of everyday life of commons, that's us, will be in the hands of those who are the principal bearers of data, physical or natural persons, or simply said, citizens themselves. As said, the first idea about GDPR was connected with protection of citizens from corporations which had power to use private data of its customers and to distribute them through their channels to various entities which did not have direct access to their original data. Of course, in that respect, GDPR was necessary, but as it is the case with many big changes, it was not possible to foresee all possible consequences of such intensive legislation. Well, I'll talk mostly about how GDPR regulation potentially jeopardizes freedom of religion, which churches and other religious communities and/or organizations enjoyed for years. This is connected with the right of the religious community to organize its practices and beliefs according to its own traditions and needs. This is obvious setup of the European Convention on Human Rights, which in its Article 9 protects freedom of religion, as well as is the case with Article 10 of the Charter of the Fundamental Rights of the European Union. I will show, and I did most of my research in this part of the project, that extensive use of GDPR regulation could harm religious freedoms, which have two major components. First one is connected with individual rights for and of religious freedom, and second one, which is collective right of religious freedoms, which is embedded into institutional insights of religious entities to operate freely. In that sense, religious freedoms concept cannot be fully understood if there is absence of any of those two components: individual freedom of religion. What that means, individual freedom of religion? It means that I can believe whatever I want. And not just that I can show that I believe in whatever I want. But not just that I can try to convince others to follow me in what I feel that is right to believe. These are three major components of being free to practice religion. It is not possible to be religiously free if the institution or organization which someone is a member does not have prerequisites to operate freely according to practices and creeds of that particular group. In that sense, a citizen belongs to a religious organization where he or she executes its rights and which operates within the system of religious norms which again legally exist in the state according to domestic laws of religious organizations. There are multiple issues connected with the right to privacy as it was established and to some extent reassured by GDPR regulation on one side and the freedom of religion on another. In this elaboration, I will try to explain a little bit about Ronald Dworkin's theory. For those of you who studied law, legal theory, something which is usually on the first year of the law school. Nobody remembers that really. But I'll try to make a few references on him, very brief ones. But on one side, there is a right to privacy, which is the right guaranteed by many international treaties and conventions. And on the other side, there is right to worship freely, a right which also has capacity of being internationally recognized right. In this scenario, we have to find a way of proportionality and balance. Balance is a key word. I heard that word many times today. And balance those rights. Another approach in search of the protection of religious freedoms, and this might be more appropriate, would be by confronting the right to privacy, to public order and public security. This will assure that documents of various religious communities, if declared a public good, have to be protected for the benefits of the society. For instance, matrimonial books as public books. I'll tell you later why this is important. Documents, which for some may look that they will fall under the scope of GDPR, have concrete ability to be declared as historical documents and also public documents. Documents of great importance which are then exempt from GDPR application. Also, as it will be explained, specific rights, also as in the Dworkin's view, have basis in human dignity and liberty, and those have to prevail over the competing rights. I was thinking about Marcin Wielec, my dear friend. He's an expert in criminal procedure, one of the best Polish experts in criminal procedure, and his work was connected with the confession and exemption of confession testimonies in criminal court. So let's not talk about, in recent discourse, we always talk about, many times I would say, about Muslims and about problems with hate speech on places where Muslim believers gather. But this is not fair to them because what if crime is agreed in confession room? So you see, we have a problem. Confession box is exempt from testimony, but then confession room also can be place where technically, I'm just talking technically, priest and person who is confessing are arguing and agreeing on some criminal action. Well, just to make things clear, I'm a Catholic, and I'm just putting this as a potential option to be fair to everybody. So it's the best to put the example from my own religion. But I will go directly to hypothetical case. All this, what I was saying, may sound strange, but I'll tell you the case. This short case would, in my view, be the perfect explanation what could and what has happened in several jurisdictions of Europe and has elements, as it was explained, of clash between religious rights and privacy laws. So there is a story for you guys. Ivan, common Croatian name, János, is 20-year-old young man born in Zagreb, in Croatia, and he was baptized. And this was usual practice when he was 6 months old. 6 months old infant in the local church of St. Joseph. His parents were devout Catholic and regular attendees of the Holy Mass on Sundays and holidays. When he was 16, he started to fight with his parents. Everybody who has kids knows that this can happen. He started to fight with his parents about reasons why he has to go to church and about, in his views, inappropriate behavior of some clergy regarding political activism and activities. At the same time, church was facing serious problems regarding pedophilic scandals, and he decided to stop going to church services. During subsequent years, he departed himself from the church and church teachings. When he moved from his parents' house, he decided to go to his local parish. He decided to go to his local parish priest, nice guy, a wonderful man who followed him during many days of his youth, and he requests his erasure from the church books as he decided that he does not want to be baptized anymore. Wow. His friend Marco, who is a law student graduate, told him that there is GDPR. Listen, Ivan, there is GDPR. Just use it. Use it against the church. So there is a GDPR regulation, and that he has right to be forgotten. Wow. His priest, Father Mate, tells him that he cannot be erased from the church books because canon law of the Catholic Church does not accept erasure of sacraments. There are some exceptions in matrimonial law, but not in baptism. And that only action he may do is to put annotation on the specific place or in the church registry book that baptized person has left the church. He explains to him that for the Catholic Church, he will be forever Catholic. Unum baptizatum, semper baptizatum. When once you are baptized, you cannot erase your baptism. This cannot be changed, Father Matthew says. His anger was so strong that he decides to press on various fronts in order to have his name erased. What Ivan and Father Matthew didn't know was that the church books and church registries are not only books which belong to the normative order of the canon law of the Catholic Church, but also that they are public documents which contain data, for instance, important for marriage. Therefore, baptism records are an important part of that process. Same is with confirmations. Church books are not only public books, but they are part of the mechanism how the church works and operates. They are necessary for citizens who are believers in order to have access to verified documents, which then can be used for performing religious ceremonies. Religion is not only about spirituality and theology. Its work and scope of activity includes lots of paperwork and documentation as a preparation for actual spiritual act. Therefore, those documents are important for religious life, and pressure on them is pressure on religious freedom. And then again, in this case, Croatia has agreements signed with the Holy See. Those agreements are part of the Croatian legal system. I'm talking about Croatia, I'll talk about other Central Europeans soon. Has agreements with the Holy See, and those agreements are part of Croatian legal system, which was in place even before Croatia has decided to join the European Union. Also to add, church documents have this historical value, and church history is in all European countries part of history of the nation, regardless of the numbers or percentage or of believers. Excuse me. Just to find, yes. So about religious organizations, and what is the core question here? How to balance between individual and collective public right? To sum up this part, GDPR will obviously will have its impact on religious communities, regardless of the fact that it has been made for business entities in the first place. Relatively recent judgment of the European Court, Jehovah's Witnesses, Jehovan Trojstjat case shows that the Luxembourg court considers religious communities as subjects of GDPR. What this was all about? Jehovah's Witnesses, you know, those guys who are coming to your door, and they ask you to join their movement, which actually they have right to do. We are a free society, so you can choose you want to follow or not. Yeah, but they collect names of people who they visit. So there was a judgment of the court that if they do that, they have to have data controller. So obviously, GDPR, in the opinion of the court, will be part of, also will catch the religious entities, religious community. But it's not all that simple, because you have international law, you have treaties. I was talking about I always try to talk about this from the perspective of our countries, from those flags are here. Most of countries from Central Europe have agreements with the Catholic Church, with the Holy See. Czech Republic is an exception, of course, Serbia also. But most of countries from our region have agreements with the Holy See. And church documents are, Slovakia has agreement. And church books are public books, and they are protected because the data that somebody is baptized is connected with the options being married or being godfather or godmother. So it has this public element. So it's a huge issue, actually. Just to say a few words about those agreements, that we have parallel system. Catholic Church and other religious communities, through their own glasses, are moral persons, but in the real life, those are legal entities with very own structure organized through canon law or some other religious law. All this makes somehow complicated mixture of norms and rules which have to be followed both in religious and secular civil legal system. Catholic Church is organization sui juris, but also sui juris, sui generis and sui juris. Countries which have signed agreements with the Catholic Church, and especially if those agreements existed before entering the European Union, make integral piece of respective state constitutional systems, especially so that constitutions themselves contain regulations about specific position of their state church. Taking all this into account, a careful examiner will come to a conclusion that privacy issues when we discuss religious organizations are sensitive. Firstly, for the special place of which religion still has among vast majority of citizens of Europe. Secondly, for the sake of protection of rights which are guaranteed to religious life, people who do practice religion. And thirdly, for the fact that the church records are of public or archive value. One should understand that there isn't personal religious freedom if collective or organizational religious freedom does not exist. This is just elementary. You cannot say there is a religious freedom, but then organization you belong to doesn't have right to fulfill religious obligations and duty according to the principles of that particular religion. You know what happens in Europe? I talk with colleagues who are working on law and religion issues, that there are very many hostile groups who actually are, especially in some countries in Western Europe, who are very well organized and pressing church authorities erased from this clash between privacy and religious freedom. I was mentioning Dworkin. He said that someone who claims a political right makes a very strong claim, that government cannot properly do what might be in the community's overall best interest. He must show why the individual interests he cites are so important that they can justify strong claim. If we accept that there are two principles of human dignity that he was describing in his work, we can look to those principles for that justification. We can insist that people have political rights to whatever protection is necessary to respect the equal importance of their lives and their sovereign responsibility to identify and create value in their own lives. Dworkin basically says that there are some rights which overrule or overweigh other rights and rules. Some individual rights, he states, are so important and intrinsically connected with human existence and dignity that cannot be put aside. In the basis of this notion is a concept of dignity which justifies the extraordinary force of rights in order to block policies that might further the community's overall best interests. That basically means that some rights have to exist even if those are contrary to countries' or society best interests. I disagree in one thing with Dworkin. He undermines, he just puts individual rights too much into on the forefront of rights, but and forgets sometimes importance of collectivities. But in this respect, his work and analytical tools can be used to show that there are some rights which are so important that in competing with other rights, when you value them and when you choose to value them according to the public order of the country and public morals, they will prevail. Dworkin didn't mean religion about religious freedom, but I was using his tools to prove that religious freedom is one of those rights. Historically, if we see that for religious reasons people were prosecuted, this is still in the core of most of our constitutions. And just to put it, it's a huge work I did on this. Just to sum up, churches and religious organizations have specific and special position within the European society for numerous reasons. Religious life is protected by national laws, and freedom to worship freely was articulated in many constitutional texts. Various international conventions protect religious life, notably Article 9 of the European Convention of Human Rights and Article 10 of the Charter. Special position of the Catholic Church exists in many countries where right of the Catholic Church and its relations with the state are regulated by specific agreements stipulated with the Holy See and entity of international law. At the same time, there are numerous agreements made with other religious communities. In some countries, there are state churches which have specific and sometimes privileged position within the society. All this made religious life a very delicate area of social existence and legal protection. At the same time, on more theoretical level, as I mentioned with Dworkin, there will be some rights which, in competing with other rights, will prevail. And there will be much more talk about that in future months and years, but I don't have additional time, and I was talking much more than I was planning to, so forgive me for being a last speaker with too many words. Thank you so much.